Imagine this for a moment. A federal judge issues a clear, unmistakable order late at night. Stop the deportation flights. Bring the people back. The law has spoken. And then, almost as if that order never existed, the planes take off anyway. Nearly 200 human beings are removed from the country and sent to El Salvador, a place described by human rights groups as a torture prison. That is where this story begins. This is not a routine policy dispute. This is a collision between power and law. And at the center of it stands the Secretary of Homeland Security. In Washington, accountability usually moves slowly and quietly. But this time, it is loud. A chief judge on the D.C. Circuit is seriously considering whether the secretary should be found in criminal contempt of court. Not a reprimand. Not a slap on the wrist. Criminal contempt, with the possibility of an independent prosecutor appointed outside the Department of Justice itself. That alone tells you how serious this has become. The allegation is simple and devastating. A federal court ordered deportation flights to stop. The order was clear. It was binding. It was not optional. And yet the flights continued. When a judge issues an order, the executive branch does not get to decide whether it agrees. The only lawful options are to comply or to appeal. Ignoring it is not a policy choice. It is defiance. At the same time this legal storm was building in the courts, another confrontation was unfolding in Congress. The secretary was called to testify. Sworn in. Required, by law, to tell the truth. And then came a question so straightforward it should have taken seconds to answer. Who approved the asylum for the individual who later shot National Guard members? Yes or no? Who approved it? Instead of an answer, there was evasion. Words without clarity. Long explanations that went everywhere except where the question pointed. The chairman warned her directly. Deliberately evasive testimony can be the basis for perjury. Perjury is not just lying outright. It includes refusing to give a clear answer when the facts are known and the intent is to mislead. Why did this question matter so much? Because the administration had been telling the public that responsibility for the shooting traced back to the previous administration. But when the details emerged, they told a different story. The shooter was from Afghanistan. He had received asylum. And that asylum was granted under the current administration, not the previous one. People who pay attention noticed something else immediately. Asylum cases do not usually move that fast unless there is a reason. And there was a reason. The individual had cooperated directly with U.S. military and intelligence operations. Based on that cooperation, American officials relocated him to Washington state and granted him protected status. None of this involved classified secrets. None of it was sensitive intelligence. It was a basic factual question about who approved an asylum application and when. And yet the secretary would not say it plainly. Then things got worse. As the hearing continued and the questions became sharper, the secretary announced she had to leave. Another meeting, she said. Urgent. Could not wait. But when staff checked, that meeting had been cancelled. She knew it had been cancelled. It was a pretext. A way out. Here is the problem with that. When Congress summons you, you do not decide when you are finished. Congress does. Walking out of a hearing is not just rude. It is a challenge to congressional authority. And offering a false excuse to do it raises even more serious questions. This is not theater. This is oversight. The Department of Homeland Security controls immigration enforcement, border security, transportation security, and emergency response. It holds enormous power over people's lives. Congress threatening perjury referrals. That convergence tells a story of its own. A pattern of evasion. A disregard for limits. Accountability often arrives slowly. But when it comes from multiple directions at once, there is nowhere left to hide. This is what the system is supposed to look like when it is tested. uncomfortable, messy, relentless. Because a nation of laws only survives if the powerful are bound by the same rules as everyone else. The secretary wanted the authority of a cabinet position. That authority comes with oversight. With constraints. With consequences. The coming weeks will tell us whether those guardrails still hold. Whether judges can enforce their orders. Whether Congress can demand the truth. And whether accountability still applies at the highest levels of power. Because this is bigger than one official or one administration. It is about whether the rule of law still has teeth when it matters most.